Imagine a high net worth couple standing on the steps of the New York County Supreme Court. They hold a finalized divorce decree outlining the division of millions of dollars in global assets. After months of intense litigation, they finally have a binding court order. For both spouses, this signed paperwork represents a clean break and absolute financial finality. But in the eyes of the Brazilian government, that multi-million-dollar decree is completely invalid. It is a legal ghost. For expatriates and dual citizens, international borders often act as dangerous legal voids, where a family's wealth can easily vanish. The conflict comes down to two incompatible frameworks. The United States operates on a flexible common law system, while Brazil operates on a rigid, codified civil law system. A victory in one jurisdiction can trigger financial ruin in the other. Assuming your wealth is protected universally by a single domestic ruling is a dangerous illusion. Without proper structuring, your global assets are entirely exposed to foreign confiscation, taxation, and administrative freezes. The law offices of Norca M. Shell LLC maps these cross-border traps for international families. The following is for informational purposes only and does not constitute formal legal or tax advice. Consider an American expatriate attempting to sell a high-value beachfront property in Rio de Janeiro immediately following their New York divorce. When they present their U.S. decree to the local Brazilian registry office, the sale is blocked. Because the foreign document has not been processed locally, Brazilian civil records show the couple is still legally married. To update that civil record, the owners must navigate a mandatory, highly rigorous process known as homologação de sentença estrangeira. The U.S. decree must be sent to Brasilia, where it is formally recognized and validated by the Superior Tribunal de Justiça. Until the STJ ratifies the judgment, the document has zero local authority. Without this specific High Court ratification, the owners are trapped in a paper divorce. They cannot liquidate, transfer, or manage their own physical assets. Treating a U.S. legal document as an automatic global passport guarantees your foreign assets will be frozen in a permanent legal limbo. Even when U.S. courts attempt to divide global estates, their methods fail abroad. New York judges frequently use equitable offsetting, balancing the scales by awarding one spouse the domestic family home and the other a foreign business interest. This strategy physically targets overseas corporate interests and business accounts, using assets in cities like São Paulo to satisfy a New York property division. But Brazil enforces an opposing framework, meação. Depending on the marital regime, this strictly mandates a rigid 50-50 split of community property acquired during the marriage, regardless of whose name is on the title. A Brazilian registry office looks at the U.S. judge's clever offset and sees a direct violation of their mandatory civil property codes. The registry rejects the transfer. The U.S. court order becomes completely unenforceable, leaving the offset assets stranded. A brilliant domestic legal strategy holds no value if it violently clashes with the target country's foundational civil codes. Generational wealth transfer presents a silent, mathematically devastating risk for cross-border families. The United States and Brazil do not have a comprehensive income or estate tax treaty in place to protect individuals from overlapping tax jurisdictions. Upon transfer, the U.S. federal estate tax can strip away up to 40% of total global assets. Because no treaty exists, the Brazilian ITCMD tax, up to 8%, then hits those exact same assets, compounding the devastation. Without precise, expert cross-border structuring to shield the estate, this double-dip taxation is the default setting for expats and dual citizens. Leaving two separate legal systems to process your wealth blindly guarantees that overlapping taxes will drain your family's legacy. Faced with these overlapping jurisdictions, families often attempt a flawed solution. They hire one attorney in New York and a completely separate attorney in Brazil. Using uncoordinated domestic co-counsel often results in conflicting strategies and duplicate costs, creating a point of friction where critical legal details are lost. The alternative is a single, seamless legal bridge, capable of managing both sides of the conflict simultaneously, natively translating the law across borders. Attorney Norca M. Shell provides exactly that. She holds an LLM in international legal studies and brings over 3 decades of high-stakes litigation experience to complex international matters. Crucially, she is uniquely dual-licensed, admitted to practice in both New York State and the Republic of Brazil. She translates and executes legal strategies directly, eliminating the need for uncoordinated foreign intermediaries. True global asset protection requires an advocate whose jurisdictional authority matches the precise borders of your wealth. Your assets have no borders, neither should your protection. Contact the law offices of Norca M. Shell, LLC today. All rights reserved to the law offices of Norca M. Shell, LLC.